Hello, today in this video I will be discussing who owns the copyright to content created by the ChatGPT AI chatbot. A bit of a spoiler and introduction. I think it's likely that nobody owns the copyright to many of the materials created by ChatGPT, and as I will discuss, that leads to some fairly odd results. And also, I do think, however, that some material created by the ChatGPT AI would be entitled to copyright protection, at least thin copyright protection, depending on how elaborate and creative the prompts are that are used to create the output that ChatGPT makes. So, hello, I'm Scott Lesowitz. I am a professional attorney and very amateur guitarist and drummer. Welcome to my channel where I discuss copyright and trademark issues relevant to music and YouTube. I assume anybody who clicked on this video has a basic idea of what ChatGPT is. If not, I will put up a screen right now of what ChatGPT says it does. One thing when discussing who owns the copyright to the material would be to look at whether OpenAI, who is the creator of ChatGPT, owns any copyright, and whether the user, the average person using ChatGPT through his or her own efforts, owns copyright. However, this is a little bit easier for us because I looked at the AI terms of service, and it appears that OpenAI transfers whatever copyright it has in the user-generated content to the user. So the user can either have copyright ownership because OpenAI owned it and then transferred it to the user, or because of the user using ChatGPT is new. This whole AI thing is new, especially in comparison to how old the American legal system is. So the law is in its infancy and still developing. The US Copyright Office has taken the position that it will, quote, not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author, end quote. That said, that's from the Copyright Office. Courts have the final say about whether any particular content is or is not entitled to copyright protection. So that said, I think that number one, courts still will be likely deferential to what the Copyright Office says, but also I think that the little bit of case law there is so far is consistent with the Copyright Office's position. That said, I think it's important to give I don't know if caveat's the right word. I don't know, I'm not good with words. I'm not good with talking either. I don't know, who knows what I'm good at. So anyway, but thank you for watching the channel. Thank you for supporting us. Please like and subscribe. Anyway, so it's important to emphasize that just because something is AI generated, I don't think, and I think it's pretty clear that that doesn't automatically disqualify it out of hand for copyright protection. I think the most pertinent example here, I'll give two. One is, think about you create something with Microsoft Paint. And let's say you only use the straight line features and the automatic shape features. And let's say create with some amount of creativity, you have 3 or 4 straight lines. I'm demonstrating straight lines in my hands now, even though they're not particularly straight, and a few automatic circles, and you shade them in some combination of colors. Even though you didn't draw it, it's pretty uncontroversial to assume that you have some amount of copyright ownership in that picture you made, in that beautiful work of art, at least from exact copies being made by somebody else. And then another example of technology that, and at the time was very controversial, and people were scared about what it would do for creativity and whether it would put artists out of business, and was photography. And in the case of a photo, one that's, let's say, one that's not been edited after it was taken, the camera, the machine makes the image. However, as early as 1884, the US Supreme Court found that a photographer can own the copyright to a picture, a photo that he or she took, and it was 1884, so I'm sure it was he. And the court rejected the argument that there was an insufficient human creator because the machine did it. The idea being that it's an important concept for copyright law, I'll emphasize it now, that the level of creativity and originality for copyright, there is a creativity slash originality requirement. Facts cannot be copyrighted, ideas cannot be copyrighted, nature cannot be copyrighted. But the idea is that the photographer does take some creative steps in terms of when to take the picture, exactly what to include in the photograph, the lighting, how the picture is taken, etc. And those things together, the courts have held, can be enough to warrant copyright protection. So there you go. And to me, that is similar to AI, sort of, but we'll talk about that more. So, but that said, there has to be a human author for copyright purposes. That's just how it is. Same thing for patent law, and this has actually been firm case law on this, that there has to be a human inventor for patent law. The Ninth Circuit found that the maker, the programmer of a CAD program did not own the copyright to files created from an unauthorized use of the program. I'm going to quote from the Ninth Circuit's here. This would be, quote, this would be if the program, quote, does the lion's share of the work, unquote, and that the user's role cannot be so, quote, marginal that the output just reflects the program's content. I think that if we look first at whether OpenAI ever would own any copyright in what's created from the ChatGPT, I think the answer is probably going to be no, because in the case of a video game, let's say, somebody actually, some human created, directly created the images, directly created the sprites. Whereas in the case of ChatGPT, the programmer really just created the mechanism in which the AI is able to, figure out and generate an original answer to an original question. And so I think the work of the programmer is too remote in terms of the answer that's actually supplied, the material that's actually supplied by ChatGPT. Now, but let's look at it from the point of view of the user. Does the user, through his or her own, creativity in operating ChatGPT through the prompting, obtain any copyright? I think the answer is, like many good legal questions, for better or worse, the answer is it depends. I think usually it's mostly, really the courts haven't answered this yet, so I'm kind of assuming, but I'm assuming the answer is likely going to be no in most cases. If someone's using ChatGPT and just asking it to write something on a topic or give information about it on a certain subject, or even like create a story about something, I just don't think that's going to be enough. Copyright, again, does not, if maybe it's the first time I've said this, copyright does not protect ideas, it does not protect facts, it only protects the expression of facts and ideas. That said, the amount of expression and creativity is fairly small, and sometimes even just an original way of presenting facts or ideas, and how you order them and whatnot can be receive some thin copyright protection. So I think that copyright protection might happen in the case where somebody can analogize himself more to someone who's taking creative decisions beyond just seeking information about topics. So the user should be able, who wants copyright protection, should be able to show that he or she, through the prompts used, made creative choices about, creative non-functional choices about what the text that the AI made. I think it'll be very fact dependent. I think it'll be a somewhat uphill battle, especially for early litigants. And the person really should show elaborate prompting that really showed some creativity, maybe more than what normally you would think would be required because it's so new and you do have that Copyright Office guidance. So this leads to some interesting results, or almost weird results. If most of the materials made by ChatGPT are not copyrighted, that means they'll be in the public domain and presumably anybody could use them. Anybody would be free to use them. So let's say somebody creates a YouTube video using ChatGPT, just has ChatGPT spew out a script for the person. And I don't want to say this in a negative light. I mean, come on, I can't blame people for doing this. And imagine people doing that are watching this video, so I don't want to offend them. I'll take likes and subscribes from anybody. Nearly anybody. I think that the script, the words they use in the video, because they're probably not just ad-libbing like I am to a degree. I think that in those situations, anybody could just make another video with the identical script, the identical words being used, and the first person would have nothing they could do about it. If they do have images and stock video, let's say, running, even if that is freely available or public domain or really old, probably the choice in how they sync up the images and video with the words and the order, there might be some copyright protection there. So the visual part of the video still would probably get some copyright protection. And then if the voice is just an automated voice, like from a automated reader, probably the voice could be used as well. But if it's the person reading, actually reading it, then probably not. So that's what I think. Now, obviously, still not a good idea to do that, because you risk that the person did edit the ChatGPT script, or that the person just didn't use ChatGPT. Although some people apparently are open about it. And so with that said, I hope that was entertaining. Please like and subscribe.